Morning, everyone. Yatra naryastu pujyante ramante tatra devtaha. Yatro tastu na pujyante sarvastatra kriya. Where women are worshipped, their lives the God. Wherever they are not worshipped, all actions result in failure. Good morning to one and all. I, Akash Gupta, on behalf of Prestige Institute of Management and Research in Gwalior, would like to welcome you all into the webinar on Deface the Acid Attackers, Resilience Against Violence. Morning, everyone. Sponsored by Naryastu Pujyante. On Deface the Acid Attackers, Resilience Against Violence, sponsored by National Commission for Women, New Delhi. Prestige Institute of Management and Research Gwalior is an autonomous UGC NAC accredited A-grade institute, and MBA course is accredited by NBA. It was set up in the year 1997 by Prestige Education Society, Indore, registered under the Societies Registration Act 1860. The society was set up by Prestige Group of Industries with an objective to meet the widely felt need for the globally oriented management, information technology and legal education and training for professionals. The institute has grown to be recognized as the premier institute for the higher learning. It is a major learning center in central India. The institute has the approval of All India Council for Technical Education and as well as Bar Council of India, and it is affiliated with Jivaji University, Gwalior. Let me talk about something important about NCW, that is National Commission for Women. The National Commission for Women was set up as a statutory body in January 1992 under the National Commission for Women Act 1990. The objectives of the National Commission for Women is to review the constitutional and legal safeguards for the women, recommend remedial legislative measures, facilitate redressal of grievances, and advise the government on all policy matters affecting the women. In keeping with its mandate, the Commission initiated various steps to improve the status of women and work for their economic empowerment specifically. It took up the issue of the child marriage, sponsored legal awareness programs, Parivarik Mahila Lok Adalat, and reviewed laws such as Dowry Prohibition Act 1961, PCP and DT Act 1994, Indian Penal Code 1860, and the National Commission for Women Act 1990 to make them more stringent and effective. It organized workshop, consultations, continued expert committees on economic empowerment of women, conducted workshop seminars for gender awareness, and took up the publicity campaign against female feticide specifically, violence against women, etc., in order to generate awareness in the society against these social evils. When we chose this particular topic, like Deface the Acid Attackers, Resilience Against Violence, now this particular screen is showing the glimpse of it. The problem of acid attack in India rising day by day. There are hundreds of complaints which are unregistered and untold. The victim of the acid attacks are fighting for their social status after the heinous incident. Data suggested that the cases which are unregistered are having the huge number in actual. Though we have penal provisions to combat against this social evil, but the whole implementing agency need to come together to decrease the cases of acid attacks. We have very profound resource persons from the various streams to talk on the matter, which itself is having the great concern. I would like also like to welcome our director, Dr. Nishant Joshi, Prestige Institute of Management and Research, Gwalior, Deputy Director Management, Dr. Navita Nathani, and Deputy Director Law, IT and Commerce, Dr. Tarika Singh, and Head of the Department, Dr. Praval Pratap Singh, and all the esteemed faculty members and attendees. Now, I would like to call Dr. Tarika Singh, Deputy Director, Law, IT and Commerce, Prestige Institute of Management and Research, Gwalior, to address the gathering. Ma'am, over to you.
Thank you, Akash sir. And I hope I'm audible clearly.
Yes, ma'am.
Yeah, very warm good morning to the renowned speakers of the session and the participants of the webinar. And I extend warm welcome to everyone present virtually here for the webinar, naming Deface the Acid Attackers, Resilience Against Violence. It is sponsored by National Commission of Women, New Delhi, and on behalf of Prestige Institute of Management and Research, Gwalior, we welcome you everyone. Today, we'll listen to the experts on the issue which is less discussed and avoided to be discussed. The violence assault, which has both long-term physical and psychological impact on women, as far as far-reaching social, psychological, and economic complexities. Acid attack is a form of gender-based violence aimed at silencing and controlling the women. Unfortunately, in India, there was no separate legislation to deal with the acid attack before the passing of the Criminal Law Amendment Act 2013. Indian Penal Code has provided reassurance to the victims under Section 320, 322, 325, 326, and 307. But what we understand is it is seen that these sections do not fulfill the profoundness that is required for the earnestness of the offenses. Police, judiciary, they are there with their rules. Laws, landmark judgments are there, they form the backbone. Financial compensations are talked about. But are this enough for the victims? Amendments to the law and a judgment of the Supreme Court addressing the acid attackers have failed to stop the crimes against the women. Out of the incalculable number of violence, acid attack is considered to be the most horrendous and awful kind of violence, where the woman is made to suffer for no blunder and blopper on her part. How far this is justifiable and tenable? What is their culpability? Are they not human beings? Is in the acid attack worse, shuddier than the rape? Do they not have right to live with self-respect and serenity? Should they continue to suffer as they have been? Should they continue? Should the society continue to pester, agonize, and torment them the way they have been doing? Do they deserve such a pathetic and wretched treatment by the society? Are the provisions in IPC sufficient to curb such kind of violence? There are many more such questions to keep cropping and haunting us. These questions require an answer, and I hope the discussions today will help us reaching to them. Let's deface the attackers. Thank you.
Thank you so much, ma'am. Moving ahead, I would like to introduce the profound speaker for today's session. The first speaker, as investigation is the process which is to be conducted for the collection of evidence. The whole judicial process directly depends on the investigation. It demands integrity and dedication. And we have the first resource person who is having the same amount of caliber, CSP Mr. Ravi Bhadoriya. Sir is working under the State Police Services. Sir has completed his Bachelor of Science and Master of Science from the Government Science College, Gwalior. Right now, he is serving as the Chief Superintendent of Police, Maharajpura Circle, Gwalior. We welcome you, sir, in our webinar. Kindly enlighten us with your thoughts. Thank you so much, sir. Over to you, Ravi, sir.
Thank you, Akash ji, and hello to everyone. I think I am here from enforcement agency, and our part is to deal at the first hand as a part of judiciary system, because any complainant and any incident like acid attack, it comes to police at first hand, and then our duty starts with the very initial point of a crime. So we are dealing it very professionally way, and as our earlier speaker told us, Criminal Amendment Act 2013, after the incident of Lakshmi case, section 326A and 326B added in IPC, and Simultaneously, 154 CRPC is also amended for particularly dealing with this type of case. हमारा जो पार्ट है उसमें हमारा जो सबसे पहले जो प्राथमिकता है इस तरीके की जो हीनियस ऑफेंस है उसमें फरियादिया या जो पीड़िता है, विक्टिम है, उसके साथ जो हमारा ग्राउंड स्टाफ है, जो थाना एक यूनिट है, पुलिस स्टेशन जो फर्स्ट यूनिट है जो इसको डील करती है, ऐसी किसी भी घटना की सूचना मिलने पे हमारे बहुत स्पेशल सभी को डायरेक्शंस हैं कि सबसे पहले सीनियर्स को सूचना दी जाए, जिससे कि सीनियर्स डायरेक्टली इसमें इन्वॉल्व हों और फर्स्ट हैंड पे कोई मिस्टेक ना हो। और सबसे जो फर्स्ट हमारा प्रायोरिटी होती है कि यदि कहीं एसिड अटैक की घटना हुई है तो हम पीड़िता को सबसे पहले मेडिकल एड विद इन नो टाइम अवेल करा पाए। सबसे जरूरी जो काम है वहां पहुंच के ना ये हमारे निर्देश होते हैं कि पीड़िता को थाने आने के लिए रिपोर्ट लिखाने के लिए ना आना पड़े, उसके पहले पुलिस उनके पास पहुंचे और उनको तत्काल लेकर के नियरेस्ट मेडिकल फैसिलिटी पे लेके जाएं और उनका ट्रीटमेंट स्टार्ट हो। और एफआईआर रजिस्टर करने के लिए भी उन्हें थाने ना आना पड़े और वहीं पे यदि सी इज इन कंडीशन एंड वेल ओरिएंटेड एंड कॉन्शियस टू give a statement, then first without delay a statement should be recorded. And as you know, in the amendment in 154 CRPC there is a proviso, a woman police officer will write the FIR. दूसरी जो हमारी प्राथमिकता है कि एफआईआर बहुत फैक्चुअल और विदाउट एनी फॉल्ट लिखी जाए और उसमें जो सारे फैक्ट शामिल होने चाहिए, बिकॉज एफआईआर इज द बेस ऑफ टोटल जुडिशियल प्रोसेस। तो जो हमारा आईओ इन्वेस्टिगेशन ऑफिसर एफआईआर राइट करे उसमें वो सारे फैक्ट शामिल हों जो की घटना में क्यों, कैसे, कब, कहां, सारे प्रश्न उसमें इंक्लूड हों और एक तथ्यात्मक प्रथम सूचना लेख की जाए। साथ ही उसके तत्काल बाद जो हमें एविडेंस कलेक्ट करना है उस एविडेंस को कलेक्ट करने के लिए हम एफएसएल टीम से, फॉरेंसिक टीम से उस साइट को, क्राइम स्पॉट को विजिट कराएं, फोटोग्राफ्स कराएं और जो फर्स्ट हैंड एविडेंस हैं वो किसी भी तरीके से छूट ना जाएं। लाइक एसिड के से जले हुए यदि कपड़े हैं वो सीज हों एमएलसी के वक्त, फोटोग्राफ्स प्रॉपर हों, अगर एसिड के अवशेष उस घटना स्थल पे हैं उनको हम कलेक्ट करें और साथ में एसिड का सोर्स कहाँ है, वो एसिड जो एक्यूज है वो लेके कहाँ से आया है उसको हम कलेक्ट करें, उसके बारे में जानकारी हासिल करें। और इस सारी प्रोसेस के साथ साथ साइमल्टेनियसली हम एक्यूज्ड को अरेस्ट करने पे और कस्टडी में लेने पे को प्राथमिकता देते हैं, जिससे कि वो कहीं दूर भाग ना जाए और फरार ना हो जाए, एब्सकॉन्ड ना कर जाए। तो साथ ही एक टीम जो है हम तत्काल उसको एक्यूज को अरेस्ट करने के लिए भी अपने एफर्ट साथ ही चालू करते हैं। और इसके साथ साथ कई बार ऐसी घटनाओं के बाद मीडिया हाइप और एक लॉ एंड ऑर्डर सिचुएशन भी क्रिएट होती है, उसको भी हम लोग साथ में डील करने की कोशिश करते हैं। इसके अलावा इसमें एक पुलिस का पार्ट और है जो ऑनरेबल एपेक्स कोर्ट ने लक्ष्मी केसेस में ही डिसाइड किया है कि जो एसिड को सेल करने वाले हैं उनके ऊपर निगरानी की जाए और पर्टिकुलर कंडीशंस एपेक्स कोर्ट ने दी हैं कि कोई भी जो एसिड बेचने वाला है वो एक रेगुलर रजिस्टर मेंटेन करेगा और जिसमें वो ये जानकारी रखेगा कि कोई एसिड क्यों खरीद रहा है, उसका एसिड खरीदने का मोटिव क्या है, उसके अलावा उसके पास क्या स्टॉक है, उसके अतिरिक्त वो किसी माइनर को, बिलो 18 ईयर्स को कभी कोई एसिड सेल नहीं करेगा। जो भी एसिड खरीदने वाला है उसकी एक फोटो आईडी वो रखेगा और साथ में हर 15 दिन में, एवरी 15 days, he will submit a report to concerned sub-divisional magistrate about the stock and उसके रजिस्टर के बारे में उनको चेक कराएगा। ये इन प्रोविजंस का भी पालन हो रहा है कि नहीं, एज ए इन्फोर्समेंट एजेंसी हम लोग इसका भी ध्यान रखते हैं और ये सारे इन्वेस्टिगेशन को हम एक अपने प्रोसिक्यूशन एजेंसी के सीनियर पर्सन के साथ कोऑर्डिनेट करते हुए सारे एविडेंस कलेक्ट करते हैं। जो उसके विटनेसेस हैं उनके प्रोटेक्शन के साथ उनको ट्रायल में हम लोग लेके जाएं, विटनेस को कोई थ्रेट ना करे। हमारी भूमिका सिर्फ एक केस को रजिस्टर करके और उसका चालान करने तक सीमित नहीं है, हम उसको बाद में उनके विटनेस को किसी भी प्रकार का प्रेशर, किसी भी तरीके का उनके ऊपर दबाव ना हो और किसी तरीके से उनको प्रभावित ना किया जा सके, ये भी हमारी जिम्मेदारी है। और ऐसे सारे एसिड अटैक के सारे केस को हम चिन्हित या आइडेंटिफाइड केसेस में लेते हैं हमारे स्टेट में और उनको ट्रायल के एंड तक उसके को फॉलो किया जाता है और इसके लिए पर्टिकुलर एक टीम, एक गजेटेड ऑफिसर के डीएसपी रैंक के ऑफिसर के अंडर रखी जाती है, जो लोग वहां प्रोसिक्यूशन के साथ मिलकर उसके जजमेंट तक, केस के जजमेंट तक हम उसको फॉलो करते हैं। इसके अलावा मैं ये इन्वेस्टिगेशन में मोटिव जो है क्रिमिनल का, कि इस क्राइम करने के पीछे उसका मोटिव क्या था, उसका क्रिमिनल बैकग्राउंड क्या है, उसका सोशल बैकग्राउंड क्या है, ये भी हमारे इन्वेस्टिगेशन का पार्ट होता है, जिससे कि हम इसके इस तरीके के क्राइम के सोशल बैकग्राउंड को या सोशल कॉजेज को भी समझ सके। दैट्स ऑल आई थिंक फ्रॉम माय साइड।
थैंक यू सो मच सर, रवि सर। हमारे पास अभी कुछ क्वेश्चंस इससे संबंधित आए थे इन्वेस्टिगेशन एजेंसी से। तो अभी एक पार्टिसिपेंट जिनका नाम कृतिका है, उनका पूछना है, इफ द पर्सन हु इज परचेजिंग एसिड इज लाइंग अबाउट द रीजन ऑफ परचेजिंग देन इट हैज नो रेमेडी सॉल्यूशन। अगर कोई व्यक्ति एसिड परचेज कर रहा है और उसके पास कोई एक युक्त कारण नहीं है ये बताने के लिए कि एसिड खरीदने का उसका औचित्य क्या है, तो क्या इससे संबंधित कोई प्रावधान या कोई चेक एंड बैलेंस पुलिस ऑफिसर या इन्वेस्टिगेशन एजेंसी अपना सकती है या नहीं?
ये बहुत स्पष्ट है एपेक्स कोर्ट की गाइडलाइन में कि बिना किसी औचित्य के किसी को कोई एसिड सेल नहीं किया जाएगा। अगर सेल करने वाला व्यक्ति इसका उल्लंघन कर रहा है तो उसके ऊपर एसडीएम को पावर है 50,000 अप टू 50,000 जुर्माना करने के, और ये इसका पालन किया जाता है।
जी सर, दूसरा प्रश्न हमारे समक्ष आता है, ये तरुण प्रताप सिंह कुशवाहा द्वारा किया गया है। प्रश्न वो ये पूछना चाह रहे हैं कि अगर हम बात करते हैं एसिड अटैक के मामलों में इन्वेस्टिगेशन के लिए, तो जब अन्वेषण की प्रक्रिया चालू होती है तो क्या कुछ एक नियत दिनों के भीतर ही इस अन्वेषण को कंप्लीट किया जाना जरूरी है, या फिर इसके लिए अन्वेषण एक सतत प्रक्रिया की तरह ही चलता रहेगा?
इसके लिए कोई पर्टिकुलर एक टाइम लिमिट फिक्स नहीं की गई है, लेकिन जैसा कि मैंने पहले कहा कि इसको हम मोस्ट प्रायोरिटी के ऊपर लेके करते हैं और विद इन 15 days और हार्डली 1 month इस तरीके के इन्वेस्टिगेशन कंप्लीट किए जाते हैं। इससे ज्यादा इसमें समय हम लोग नहीं लेते और कानून की जो मंशा है 173 सीआरपीसी में कि स्पीडी एंड विद इन्वेस्टिगेशन जो है किया जाना चाहिए, उसका पालन किया जाता है। और 15 डेज, मोस्टली 15 डेज के भीतर इन ऐसे मामलों में हम लोग चालान करते हैं।
सर, एक प्रश्न नंदिनी अग्रवाल के द्वारा किया गया है। ये प्रश्न भी एसिड अटैक से संबंधित है। उनका पूछना ये है कि अगर जानते हुए भी कि ये केमिकल इतने खतरनाक है कि जिनसे घटनाएं इस तरह की बढ़ती ही जा रही हैं, तो क्या उन पर रोक लगाया जाना जायज नहीं है?
देखिए, एसिड की जरूरत अनेकों चीजों के लिए होती है। लाइक हम लोग स्कूल्स में, कॉलेजेस में, लेबोरेटरीज में एसिड यूज होते हैं फॉर केमिकल एक्सपेरिमेंट्स, एंड हॉस्पिटल्स में यूज होते हैं। इसके अलावा कई सारे डिपार्टमेंट्स हैं, ऐसे इंस्टीट्यूशंस हैं जिनमें यूज होते हैं, और रिसर्च के लिए यूज होते हैं। तो इसको बैन किया जाना पॉसिबल नहीं है। बैन की जगह इसको रेगुलेट किया जाना और उसके ऊपर निगरानी किया जाना जरूरी है। तो सारी एजेंसीज जो इससे जुड़ी हुई हैं, चाहे वो हॉस्पिटल्स हों, लेबोरेटरीज हों, एजुकेशनल इंस्टीट्यूट्स हों, इन सभी को इस पे निगरानी किया जाना चाहिए और बहुत इसको संवेदनशीलता के साथ डील करना चाहिए।
Thank you so much, sir, for your thoughts, sir. Thank you so much, sir.
थैंक यू।
Yes, sir. Moving ahead, an academician is the one who teach the whole society and always focuses on the betterment of an individual. We have a very renowned professor, Dr. Vikas Gandhi, with us. Sir is an associate professor at Gujarat National Law University, Gandhinagar, having immense experience of teaching specifically in alternative dispute resolution and international human rights. Sir has designed new courses like international commercial arbitration, investment arbitration. Sir has published 2 books and more than 40 articles in the well-reputed journals. He has been called for the special lectures in National Judicial Academy, Bhopal, and Gujarat Judicial Academy, Gujarat High Court. We feel immense pleasure to have you, sir, in our webinar. I'm handing over the session to you. Over to you, Vikas, sir.
Thank you, Akash. Thank you so much. I think I'm audible, and then screen also is visible.
Yes, sir, your screen is visible.
At the outset, let me thank for giving me this opportunity to have a wonderful academic discussion on a very contemporary issue, jointly organizing by the PIMR Gwalior and the NCW. I thank Dr. Prabal, the HOD department. I thank Dr. Tarika Singh, Deputy Director, Law, IT and Commerce. I thank Navita, also Deputy Director of Management, and Dr. Nishant Joshi, the Director at Gwalior. And obviously all the participants and who is sharing my dais, distinguished speakers and distinguished individuals in the profession. Let me go with the topic which as an academician would be more focused on the research part in this area. And when I started researching on that area, since last 1 week, I'm researching on this. And there are few points which I now like to discuss with all the participants. The issue is about the legislative in total, how many legislations that we can find today in the name of deface the acid attackers, reliance against violence. Let me go with the first slide of it. So today my discussion would be on how many total number of provisions exist in different acts, different rules, which speaks about the deface of the acid attackers. Certainly, I also concentrate much more on the part of the NALSA. I also concentrate on the part of the investigating agency and Honorable Supreme Court and the various high courts decisions. And the question is about how far the situation in terms of the Deface the acid attackers has been developed today. So all about the contemporary issue. But before we move on the practical aspects, let me go with the legal provisions. Our discussion would be on the implementation part, obviously, but basic is that what exactly the provision speaks about and where requires to make some changes into the laws, if it is, right? Because it might be difficult for the NGO also. Sometimes it might be difficult to implement the provisions. Sometimes it's for the investigating agencies as well. And top of that, it's really tough task for the honorable courts at the time when they may not be interpret the way that they want to interpret the provisions. So it means that that is the role of the academician, that to discuss the provisions in depth with the proper interpretation of the words used by the legislatures and can help to the society. And that's why this topic which I have chosen today, it's legislative provisions to deal with the acid attacks in India in total. Now, if we go with the first part, first slide, there was no such an express law pertaining to the acid detectors till 2013, I would say, because it was included into the grievous hurt definition. That attack were included into the grievous hurt definition, which we all know about the definition of the IPC. So there was a PIL. So obviously NGO's roles comes very wide in this way. And we know, and my previous speaker also mentioned about the Lakshmi's case, which is well landmark judgment, as you can say. On the bench was Honorable Justice Madan Lokur and Yuju Lalit, who has passed this verdict on a very first time in the history of such kind of act, and has given in proper judgment, I would say, saying that this acid attackers act, that particular act has to be differently expressed into the legislation. So the grievous punishment can be given, right, to those who are responsible for that. Since, as I said that earlier, it was under the definition of the grievous hurt, by which it impacted directly on the punishment side, right? So here the punishment has been, the intention was that punishment might be increased, considering is a very serious crime committed by an so-called accused. So the first point here is about the issues which dealt by the Honorable Justice Madan Lokur and Yuju Lalit is about for making considerable amendment. They suggested in 2013, in fact, because this case was filed in 2006. So almost the judgment was in the favor of to make such an amendment into both the criminal laws, that is Indian Penal Code and the Criminal Procedure Code. Number two, it's about the question discussed in detail in this case, that for the easy availability and the distribution of the acid counters. And I know that one of the questions was, which was asked in the previous session, if there is identity has been revealed or has been given in a misrepresentation, then what will happen? Obviously, the answer would come in this session as well. Third is about the free from the expenses and the surgeries and other medical treatments. Now, this is quite interesting point. Otherwise, to calculate the compensation, it's completely a sometimes discretionary power of the Honorable Court, based on the facts and the circumstances, how it's serious about. Here, the guideline is very clear. The issue is discussed in very detail by the bench, and compensation to the victims considers an physical, mental trauma and the emotional and mental hurt both. It means together. So there are two things distinguished in the point number 3, and I would prefer to say an emphasis more on. One is that medical expenditure of any surgery or any medical treatment would be distinguished from the compensation to be given to the victim. So it means that the ratio so far as the financial assistance is concerned to the victim is much more higher, has been calculated by the Honorable Supreme Court in 2014. And then top of that, rehabilitation, where NGO works very nicely, rehabilitation of the victim, acid victim, These are the major 4 points which were discussed, and obviously today also it has been implementing regarding the expenditure and the rehabilitation. Right, these 2 points are very, very crucial so far as the victim's point of view is concerned. Now here the first is strict law, which you can read here on the slide, is about strict law. Now this judgment was passed by the bench in 2014, but before that there was a guideline or recommendation, you can say, made by the Justice J.S. Verma's commission, and we all know about this commission, who is the you can say that is the former Chief Justice of India, and along with Justice Leela Seth, who was a former judge of the Delhi High Court, and I think the first women judge also in the Delhi High Court, and then the former Solicitor General of India, Sri Gopal Subramaniam. So there were 3 distinguished jurists, you can say. So they were made and recommendations in 2013 itself. And as I said, there was no such a distinct law so far as the ST categories penal provisions are concerned. It was included in the grievous hurt definition. But this recommendation was simultaneously given. Why simultaneously? Because in 2014 that we can see the judgment passed by the Honorable Supreme Court with a very proper and clear guideline. And then at the same time, this suggestions also been made by recommendation also made by J.S. Verma's committee. And there are few things which I have highlighted. The first is that they should not be clubbed under the provisions of the grievous hurt. Second is about the recommendation made, and it says that if it is not clubbed with the grievous hurt, then the punishment would be increased by 7 years, right? With the 7 years imprisonment, and recommendation was that IPC's provision need to be changed. Then imprisonment for 10 years or life, which was suggested, and then corpus to the compensative victims, right? That's for the central and state government. Now, Constitution of India that we know, the expenditure list, and very ideally this commission has made it out, that expenditure should not exclusively or not only paid by the state, but since it's a central act, need to be amended. That is the CRPC and the IPC. The corpus has to be created so far as the assistance to these victims are concerned. And the expenditure would be borne by both center and the state. So that directly affects to the constitution provision, the list. I hope you understand in that way. So this has the recommendation in 2013, and obviously the 2014, the case decided by the Honorable Supreme Court on the and provided very exclusive guideline on that. Now let's see that what is the impact of these 2 you can say documents, right? One is recommendation and another is the judgment. Randomly, I would not say anything. This is the section 326A, which of the IPC, Indian Penal Code, which speaks about knowingly causing the grievous hurt by use of acid. As I said, that the amendment was suggested by the commission and at the same time by the Honorable Supreme Court, Justice U. Lalit and Madan Lokur. Accordingly, the amendment took place in 2013 Amendment Act, that you know about it. But the important part which I highlighted is about the causes grievous hurt by throwing acid. This word has been included. So you can imagine that now expanded the version of the definition of the grievous hurt here. Not only that, they also mentioned that if it is by throwing an acid, then shall be punishable with the imprisonment. And that would not be less than 10 years. So the maximum punishment is 10 years, and which may extend to the life imprisonment as well. So that much seriously taken by the legislatures, the guidelines given by Justice J.S. Verma and Honorable Supreme Court. Second point, which further 326A speaks about that medical expenses of the treatment of the victim. Now, this is very interesting. We generally read in the provision, it's about the imprisonment and the fine or both. right? This is the normal language in the IPC provisions, in almost all IPC provisions. This is something which is distinguished, and that much serious offense that has been taken by the legislature by making this amendment. And it says that it would be just and reasonable comparison with the medical expenditure, the treatment of the victim, right? So that is defining as a fine. Forget about the compensation is different, right? Here it's only speaks about fine. And then it says it's very important that, and it is quite questionable. I think those who are filing in PIL, the NGOs, they might be aware, the last sentence of this slide is, the permanent or the partial damage or the deformity shall not be required to be irreversible. This is because of technology. I'm giving an example of it. Because of technology, you may have the complete clean face off, right? By way of surgeries. Today, the medical science is so much and treatment. Medical science is so much advanced, right? That you may get a face as it is, that how it was earlier, or it may be more smarter than what was at the time when there was an acid attack. So it says that if it is reversible, still it comes under the section 326A. So if it is reversible, I'm giving an example. Otherwise, what happened that if it is reversible, if the expenditure, right, has been paid by the attacker, right, based on, or the accused, right, based on the amendment, right, he may not been punished if this sentence has not been written irreversible, right? So they says that irreversible, even if even if after treatment, right, which was required is reversed, right, it means that original face that women is getting, still it comes under the definition of the 326A. So there is no escape window for the attackers or for the so-called accused, right, in this term. This is the interpretation of the 326A, right? 326B, this is also very interesting amendment in 2013 Act, and that is again of the IPC. Now here I prefer to say that voluntarily throwing or attempting to throw the acid is also considered under the IPC as a crime. So if acid attacker has thrown and has been luckily the women is saved, still it becomes a crime. Still it's a crime. And that's why the punishment is also that much seriously taken by the legislature here. It says that not less than 5 years, right, but which may extend to the 7 years, and liable of the fine, and fine which has been defined in the previous session, right? So even attempting, it's like an attempting to murder, right? It's like an attempting to throw an acid, and suppose luckily it has been saved, the women has been saved, right? Still it becomes a crime, and that is an amendment in 326B, right? So the legislature's intention, it's very clear now that the provisions by way of amendment can be protected, women's right in that way. Now, very interesting, because of these two provisions, 326A and B in IPC, it has to be need a change, an amendment into the section 100. Otherwise, there is no meaning of it. And that's why right to private defense, keeping in mind the situation that what exactly happens at the time when the acid has been, attack has been made by an acid, and then in a private defense, if anything happens. So the right to private defense, that is under section 100 of the IPC, right? Even if it allows that, right, under the right to private defense, that includes the causing death in acid attacks, right? And that is only because of the two amendment in 326A and 326B. Luckily, she saved, right? But at the same time, in the defense, private defense, including the cause death in acid attacks. So the right to private defense in section 100, voluntarily causing death or of any other harms to assailant, right? Exercise of the right to be any of the descriptions herein after enumerated. And seventh explanation of this provision, section number 100, it says an act of throwing or administering acid or an attempting to throw will otherwise be consequences of such act, right? It means that even if under the self-defense, if anything causing death, right, it still comes under the exception, right, under section 100. So that is called an exception, right? So the protection of the women is an highest priority, we can say, that has been considered by the legislatures under section 100. Now, in 2005, there was an amendment, though there was no express provision. As I said before, 2013, there was no express provision. But in this act, the Domestic Violence Act 2005, it is in fact coming under the definition of the domestic violence. So even if acid attacks not by the strangers or not by the boyfriend, but even if any family members, right, that also comes now under the new IPC provisions, right? So it's reading the domestic violence as section 3 is directly reading it with the provisions of IPC, that is 326A and 326B, reading it with the section 100 of the IPC. And that's why, for your convenience, I just highlight these two provisions. Acid violence by family members is covered in this section, which defines the domestic violence as, and then explanation number 1, physical abuse means, right? So in this way, you can say comes under the grievous hurt, or you can say under section 3, the Domestic Violence Act. Another point which necessarily amendment was required, it's about registration of FIR, which is mandatory in the acid attack cases, as my previous speaker has elaborated and explained. Now, the consequences, I would more prefer to say here, it's clause C of 166A. It says that fails to record any information given to him. It means in the first information report, right, regarding under section 326A of the IPC, right? So now you can, I think you can connect it, the provisions also. So the language is here, it's about fails to record any information. And that is under the section 326, right? Punishable under section 326, because FIR is section 154 subclause A, right? Which you can read on the first sentence, right? So if they are failing to FIR, right, under the cognizable offense, which is punishable under 326A, right, shall be punished with the rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and fine, right? So reading it, this 166A, public servant disobeying direction under the law of IPC, right? And if they could not record the information given to him under section 154 subclause 1, obviously then under the 326A, obviously then it may be extended to 2 years. Now, the similar provision or effect of this provision that you may see under section 54A, which speaks about the identification of the person arrested. As my previous speaker has rightly said, where a person is arrested on charge of committing an offense, and his identification by any other person or persons is considered necessary for the purpose of investigation, the court direct to that person so arrested. So this is that much serious. And then if persons identifying, right, persons arrested mentally or physically disabled, then obviously the entire process would go with the, with the videographed, right? So obviously videographing is also been supporting to this, because in acid attacks, generally these provisions need to be implemented. It's because you won't find physically and mentally that victim is able to give you a proper statement to either to the police officer or to the court, right? And when the FIR has been launched under 154(1), informed to the Honorable Court or the magistrate, obviously then magistrate need to give certain directions if the case is that the victim is unable to either come down to the court, right? So the videograph of that particular statement is very essential. So in that way, it directly affects to the Evidence Act as well. I will come up with the provisions of the evidence also, because how far this statement, which is videographed, would be considered by the Honorable Court, right, and give an exhibit to that particular document, right? So obviously, these provisions directly impact on the Evidence Act. I hope you understand in this way, right? So Section 54A obviously supports, and it's need to read out frequently by the police officers, investigating agencies. Generally, they do videograph if it's so much serious case about the victim, for the victim. Now, this is in the different context I have taken up, considering as a cognizable offense. So it means that if it is cognizable offense, then police officers also can take a direct steps, right, in this particular matter. No need to take permission from the Honorable Magistrate, right, at that point of time. So if they take a cognizance, they have all rights reserved to take in cognizance under 154 subclause 1. So I'm not reading this with the first information report, but I'm reading the same provision in the context too, that investigating agencies have a direct power to investigate into that as soon as they receive the information, right, regarding the acid attacks. And that's why, provided that if the information is given by a woman, obviously the amendment under Section 326A, right, obviously then such information shall be recorded by a women police officer, because generally acid attacks you may find from boyfriend to girlfriend, I mean to say that from men to women, right? So in that way, this amendment was very essential, and that's why that also been taken care of. 154 subclause 1, but my concentration is on women police officers availability, right, at the time when they record the evidence. Now, one of the questions in the previous session, the previous discussion, I also was reading. Now, based on that, there are certain regulations which today we can find of the acid sale and procurement. And first is that the amendment which suggested by the Honorable Supreme Court in Lakshmi's case, and then Parivartan, Kendra versus Union of India, 2016 case also. Model prison possession, poisons, possessions and sales rules 2013, which is in existence today. And that rules which have been framed under the Poisons Act 1999, which is also exists today, to regulate the sale of acid, right? So you may find that is 2013 rules would be applicable if any such breach, right, has been found, right? This rules basically speaks about stored and sold and issues of license and the procurement by an individual. Remember this, because this has to be followed by every institution, including educational institutions as well, right? Individuals, educational and the research institutions, because in research institutions, basically in the science, who are running the stream science, they must have in the laboratories the acids, right? So that also be according to the rules 2013, right? Hospitals, industries, etc., etc., right? So they have to give an undertaking. So in that way, they abide with the rules, right? If the rules are breached, obviously necessary steps also been listed out according to the Act 1999, right? So rule doesn't specify any punishment so far if the rules are breached, but obviously these rules are framed under the Poisons Act 1999, which describes the punishments as well. Right? So it's a direct connection on that. And then obviously certain acids and the poisons shall be regulated under the 1999. To say, then it's very serious point. It speaks about and it's very differently taken up. 357A of the CRPC, Victim Compensation Scheme, right? That we can find, and there is an amendment also in that victim compensation. I think a host is muting me continuously. I think there is a mistake. Your cursor is on that. I think on that.
Okay, I have just.
So the obligations on the state governments in coordination with the center, as I said, the list of the constitution that prepared the scheme for providing. And then 357B, that speaks about the compensation to be in addition to fine under the 326A, as I suggested in the previous. And then I think Dr. Tarika has mentioned about this provision. It's about 357B AD, right, which speaks about the compensation to the victims. And only one point is a law student, and as an in the field of legal arena, we have to consider that the fine is distinguished with the compensation which listed under the 326A, B, C, D, right? Payment of fine, it's different. Where calculation of the compensation, as I said earlier, that it generally based on the facts and the circumstances, completely discretion of the honorable court to calculate it, right? But at the same time, it's abide with the 326A so far as concerned with the fine. And fine, it's including all medical expenditure as well. So the fine that not otherwise alike with the fines written in the other provisions of the IPC, right? So this is the point. Now the role of the NALSA and the DALSA also that we can find in the scheme 2016. Legal services to the victims of the acid attacks is an exclusive scheme introduced it. And that directly impact on 357A subclause 6. The State District Legal Service Authority, I think the other speaker from the NGO, from the DALSA will take care of it. To alleviate the suffering from the of the victim, may order for immediate first aid facilities, plus that you can say medical benefits availed free of cost based on the certificate of the police officers and the magistrate at the time, right, when it concerned. But now this was a not a good experience so far as this certificate of the officers are concerned. And because of this, you may find this an exclusive obligation under the 357C, which has been given or created of the CRPC cell, that all hospitals, either public or private or charitable, or by the central government, state government, or local bodies, shall immediately provide a first aid or medical treatment to the free of cost. And that remains an obligation. I underline the point is obligation. Any offense under the section 326A, right? So, and shall be immediately informed to the police of the incident. Now, there are two obligations, in fact, in this provision under 357C. One is it's about immediately to first aid would be given and the treatment of the free of cost, even in the private hospitals. Fund would be raised by the concurrent central and the state government, right? So that the fund which would be utilized, right, and to be paid to them. Second is that immediate inform to the police officer and investigating agencies, right? So 357C amendment is very crucial so far as this two obligations, right, given to them, these hospitals are concerned. Now, if not followed, this is also important. If 357C is not followed by the hospital trustees or by the doctors, then a directly amendment that reflects under 166B of the IPC. Punishment for the non-treatment of victim, it will cover because it's not been treated immediately, then it will come and falls under the provisions of 166B, which speaks about punishment of non-treatment of victim. And it says about whoever being in the charge of the hospital or a public or a private, right, whether run by the central government, state government, etc., etc. And if they follows contra, and it that act under the contraventions of the provisions of the 357C always shall be punished with the imprisonment of the term that may be extended to the 1 year. So those who are responsible for non-treating, including doctors as well, they are punished, that offense, that act is punishable, which may extend to a 1 year with fine, or obviously both. So there is a direct impact of, so you can say that the major provisions of for the victims, or you can say for the accused, right, which preventing to the accused, that has a direct sub clauses, right, which supports to the main amendment punishable under this 357. Now, as I said, that this amendment has a direct impact on the evidence because it has to be considered in the evidence. I give an example. If amendment made into the CRPC says that the witness statement would be recorded, and if there is no amendment into the evidence, that whether this statement would be considered legally or not, or would be exhibited or not by the Honorable Court. So unless it has been exhibited, there is no meaning to have it recorded, and there is no meaning to have an amendment into the CRPC, and the punishment increases in the IPC. So obviously the amendment, these two amendments in IPC and CRPC has to reflect somewhere into the Evidence Act. And here the testimony, its impact on 119 of the Evidence Act, and which speaks about witnesses unable to communicate verbally. So they are unable to communicate verbally. If you remember video recorded provision, they were unable to, victim in majority of the instances when there is an acid attack, the victims would be vulnerable. They may not be in the position to give an appropriate statement remaining present in the Honorable Court or before the Honorable Police Officer. Because of that, it has been recorded. And if it has been recorded, it would be considered as an orally recorded. And that orally recorded amendment that you may find under the section 119 of the Indian Evidence Act 1872, right? And then it says a witness who is unable to speak may give his evidence, make it intelligible. Evidence so given shall be deemed to be an oral evidence, right? Provided that witness is unable to communicate verbally. And this is what happens in the acid attacks cases. And the court shall take the assistance of the interpreter also, or a special educator in recognizing the statement, and shall videograph as well, right? So there is a direct impact. Another direct impact is on the section number 114 of the evidence. The court may presume the existence of certain facts. Now here I would say that there are certain presumptions made by the Honorable Court, and generally you may find that in acid attack case, I think NGO may have a more clarity on that situation. But what I presume based on the decided case laws and the explains by the Honorable Court, the facts and the circumstances is that generally you won't find witnesses at the time when the acid attacks are made, because it's in 1/4 seconds, right? In 1/4, the acid attackers attacked by the acid and then run away on a bike, or where you won't find exactly that the witness has shown everything that what was happening, right? So sometimes the victim herself may be a witness, right, in this kind of cases. That's what I presume is based on the facts that explains in the detailed case laws by the Honorable Court. So the court may presume existence of certain facts that liberty is given to the Honorable Court under section 114 of the evidence that they may take as an evidence, right? In which situation were likely to have happened regarding being had to be the common course of the natural events which might happen, or the human conduct that, and the public or the private business and blah, blah, blah. So in this case where the victims might, as I said, and I wrote also, that sole witness in the attack. So if there is no witness, does not mean that the case may be lost by the victim. That's what I mean to say here. That's why this liberty is given to the Honorable Court under section 114, that the court may presume the existence of certain facts based on the description given and the supported, the supported observations, right, by the investigating agencies. Here, the investigating agencies plays a very vital role because they are the first who has seen this incident of the crime, right? Because they receive the first information and they generally do run around these situations, right? So this is quite interesting, the role of the investigating agencies so far as exercise of section 114 of the Evidence Act takes seriously by the Honorable Court, right? And then the last case, as I uttered in the previous session, was in the previous explanation, was about Parivartan Kendra versus Union of India. This is the second case, you can say, a landmark judgment after the Lakshmi's case in 2014, where Honorable Justice M.Y. Iqbal and Honorable Justice C. Nagappan, this bench has passed an order. And this case, the petition was filed, but that petition was after the Lakshmi's case. And a decision, 3 points decision were taken by the Honorable Supreme Court, where the court decided to compensate both girls. I just want to show you that the amount that has been increased after 2 years after the Lakshmi's case, because Lakshmi's case registered in 2000, sorry, the judgment pronounced in 2014. After that, how much judiciary has taken very serious steps and taken very seriously the guidelines provided by the Honorable Supreme Court, the same court in the Lakshmi's, 3 to 10 lakh rupees. And then instructions to the hospitals once again, into the schools also, regarding sale, procurement, license, and responsibility of the person in charge. So I would underline this point, responsibility of a person in charge, right? So once you are purchasing, you have to show an identity card of yours that would be registered, and then responsibility of a person in charge who has sell or who that acid, that would be registered, because the rule says that register has to be maintained with the proper evidence. It's not merely writing the name, and it might be in a false name or might be in cheating, right? So that probably might not be possible. And then treatment and rehabilitation, right? Directed by the Honorable Court to the victims in the name of the list of the disability. Now, this is very interesting point, including the victim names in the list of disabilities. So all the government benefits and the welfare schemes benefits that victim may take in future, right? If her name comes under the list of the disabilities, right? So this is very, very important guideline, or in the decision that Honorable Supreme Court in Parivartan Kendra versus Union of India 2016, Honorable Justice Nagappan and Iqbal, Honorable Justice Iqbal, Iqbal has taken up, right? So these are the, you can say, the total number of provisions that you may find exist today, and how far this interprets by the Honorable Court and taking very seriously by the investigating agencies too. So that's all from my side. I hope you must have now known about the total number of provisions that exist today, and what are the reasons. One is the Honorable Supreme Court Lakshmi's case, and then J.S. Verma's submissions, right, on the report. These are the two responsible documents today. We may find that the laws are exist for the deface of the acid attackers. So thank you very much to the PIMR Gwalior for giving me this opportunity for this discussion. Thank you so much. That's all from my side.
Thank you so much, sir. Each and every single point was cleared by you in a very crisp and very clear manner. You have pointed out over the landmark judgment issued by Apex Court of India. We do have few queries as related to your session. One query raised by Neha Gupta, and she's asking about the use of one-stop center in these kind of cases.
Use of
one-stop center.
One-stop centers.
Yep.
Yeah. And so what's the question is?
The question was, she just wanted to know about the use of these one-stop center in these for the rehabilitation of acid victims, or in these cases, these kind of cases.
Yeah, so I think I'm not the right person to answer this question, because NGO, I think, works very nicely so far as the rehabilitation of these people are concerned. I never visited also such kind of rehabilitation centers. But so far as the doctrinal research of mine is concerned, in India after 2013, I could see that rehabilitation centers also functioning very nicely, but obviously exceptions are always there. So, and I think the NGO may give a proper response to this particular query.
Yes, sir. So the next question asked by Harshit Jaiswal, and he's asking, is the victim statement can be considered as a witness, or it would be like only the case facts?
No, case facts, because presumption under Evidence Act, section 144. That's why the 114. This is a very crucial. So it would be a statement of the victim per se.
Next question is related with this presumption part. It is asked by Ujaswini Kohli. So she's asking about the presumption. When it comes to the presumption part under section 114 of Indian Evidence Act, it comes under the diameter of may presume. Like she is asking, it should not be included in the shall presume, where court can presume yet the offense has been done, and the burden of proof will be lies on the
No, the court never take any suo moto. Let me clarify this. So far as even the presumption is concerned, presumption's meaning is that based on the circumstantial evidences provided by the police officer investigating agencies, right, that presumption would be developed. That always the meaning of the dictionary meaning of the presumption is based on the evidences, right? So a presumption is based on the facts and the circumstance that has been created. Corroborated evidences, for example. Corroborated evidence is the right example. If it supports what presumption made by the honorable court, right, it supports those evidences, corroborated evidences are supporting, then obviously 114 would be exercised by the honorable court. Because reasons also need to be given by the honorable court that why they are presuming like this. It is not assumption. Yeah.
Thank you so much, sir. I think the point which you have mentioned, I think it is well clear to all the participants connected on Zoom meeting as well as on the YouTube. So thank you so much, sir, for your a very great amount of knowledge, very great amount of innovative thinking related to this particular topic. You have explained each and every single thing in a very, very, very systematic way. Thank you so much, sir.
Thank you. Thank you so much.
So moving ahead with the program, we are fortunate enough to have Mr. F.A. Shah, Advocate, Madhya Pradesh High Court, Gwalior bench with us. Sir did his schooling from Diwan Badrinath School of Jammu, BLLB from MLB College, Gwalior. He started practicing as an advocate at Gwalior under guidance of late Shri V.K. Saxena, sir. Sir has worked as a panel lawyer, Government of Madhya Pradesh from 2013 to 2017. Sir has also worked as the government advocate, State of Madhya Pradesh from Feb 2019 to April 2020. And we are very fortunate enough to have Mr. F.A. Shah with us. Thank you so much, sir. Sir, over to you.
Thank you, Mr. Gupta. In fact, what I was planning to
sir, you can unmute yourself. Actually, your voice is not clear. Sir, your voice is not clear. Actually, kindly unmute yourself.
Is it fine? Am I audible now?
Yes, sir, it is fine now. Thank you, sir.
Yes. So, yes, I just started with saying whatever I was planning to say today, it has been virtually hijacked by Mr. Gandhi. And he has explained the things in such a nice manner and with all the citations and all the statutory provisions. So not just me, even my successor speakers will be finding it difficult to match with the standard set by Mr. Gandhi. Anyways, I'll just change my track and my gear because the law is well explained by him and the investigation procedure is explained by Mr. Bhadoriya. So I'm changing my track to the social environment and the adjustment of the victim of acid in the society. And most importantly, what the government is doing after the judgments by the Supreme Court to maintain all the documentary evidence regarding sale of acid. You see, on Diwali, we see many advertisements saying don't buy the crackers, don't burn the crackers. it will cause pollution and all that. But there is no control over manufacturing and sale of the crackers. So same thing with the acid attacks, acids also. Acid is freely available in the market. There is hardly a shopkeeper in the city who maintains such a record in his shop. And I don't think such records are ever such records checked by the police department, because we don't see any such news and we don't see any such clips in the news, in the media regarding the checks done over the sale and manufacturing of the acids. We live in Gwalior. In Gwalior, there is a market known as Didwanoli. And in that Didwanoli, you will find at least 30 to 40 shops who not just manufacture acid, they also sell it openly. Anybody may go there and buy it. The weapon of offense is so freely available in the market, then certainly curbing a crime caused by that weapon is very difficult. So my first request to the CSP Mr. Bhadoriya is that please do adhere to the directions given by the Honorable Apex Court and try to check those manufacturers and those sellers to whom they are selling and under which provision and under which license they are manufacturing all those things. As far as assistance to the victims are concerned, though there are statutory provisions which have come into being after 2013 and after the judgment of 2014 and 2016, but still those are not that practically applied. So acid attack victims are increasing every year. Though I checked the numbers on Google, so the number of cases were down in 2020. But that may be because for most of the part of the year, people were at their home under the compelling situation of the COVID. So the cases are increasing, then definitely somewhere police system is lacking. Thirdly, the courts are very vulnerable to it. And in most of the acid cases, conviction rate is very high. And in larger number of cases, the victims are the girls and the women. And one case I dealt with in which a husband was attacked by acid by his wife. So in that case, when I appeared before the court and presented the case of 326A, the first query of the court was, what is the age of the girl? So I said, sir, this is not girl, it's a man, and he is the poor husband of the wife, and the wife has attacked him with the acid. So these are very real instances, and the women are suffering more because of all this. So the things are happening like that as they should not happen. So the better would be to involve the social organizations and to make maximum and to spread maximum awareness about it and to make more people aware of the acid attack. In fact, one more thing I would like to add here. The crime cannot be controlled in a manner which, in fact, right now I am saying, or which we people believe in general. Crime takes place on the spur of movement. In India, there are just two crimes which are punishable only at the stage of preparation. That is treason and preparation for dacoity. So in such offenses, when a person is buying an acid from a shop, acid bottle from a shop, it should be interpreted as preparation of crime. If it can be done, then only it can be curbed to an extent. Otherwise, it is very difficult to curb such crimes. These crimes are taking place like pickpocketing. Anybody may be a victim and anybody may suffer the consequences of that. But somehow there is a sigh of relief. Apart from legal procedures, so many social organizations and persons and individuals have come out. They have married to the acid attack victims and all that. So things may get better only when the manufacturing and sale of the acid is controlled. Then only it can be tackled with. So as I said in the beginning, my preparation has gone in vain, but better utilized and presented by Mr. Gandhi. So I sum up by giving thanks to PIMR and thanks for inviting me. Thank you.
Thank you so much, sir, for your kind wisdom and like innovative thoughts as related to the topic. And you have mentioned the point of view from of an advocate on this particular topic. So moving further, we do have Miss Ankita Mathur with us. as every district legal service authority have major role to play for these cases about these cases. To know more about the roles of district legal service authority, I would like to welcome today's speaker, Ankita Mathur, advocate, Madhya Pradesh High Court. She is practicing since 2011 at bar of Gwalior bench. She is also working as the mediator and legal advocate in district legal service authority Gwalior. She is extensively working for the safety of the women via public interest litigations. Thank you so much, ma'am, for accepting our invitation in the webinar. I am handing over the session to you. Over to you, ma'am.
Thank you, Gashi. First of all, I thank to the PMR for inviting me to speak on such a very social topics, also a very awaiting topic. The point which I have to discuss with you all has already been discussed by my co-speaker. Now, apart from the legislation, because we have already, by our co-speakers, we have got the knowledge that what are the provisions and legislation was there. Now, the main point which arises here is many laws were made, many provisions are there, but still the main point is getting why these attacks are not stopping. There's a, in my view, there's a big role of the society, not only of the court or laws stops the crime, but it is all are we the society. Because first of all, normally in our views, we are just I simply express that we praise, we worship the Lord as in the temples and somewhere. And on the other side, we are humiliating the women in most of the society, most of the homes, humiliating the women at our home, at the workplaces, and this. And secondly, and if we consider our historical background, historical movies, somewhere we see the historical movies and historical dramas also, we see that there was a further system for the women. And they thought that, and still at present also, most of the development has been taken place, but still most of the part of the society, there is still the further system where we taught the child girl when she is in a childhood that your male is superior to you. You always have to follow the male. You always have to take his opinion first. And on the apart from male to a male child, to a boy child, we are teaching that you just have to see the woman. She's not superior to you, which means that the education we have to give to the boy or a man relating to the respect of the woman or a girl. Because the main reason occur because, for the acid attack by the man or a boy, that reason is which affect their ego. That ego occurs mostly because of the when their love turns into a hatred. Many of the cases, or most of the cases, they are the cases when a boy tries to propose a girl. He thinks that I am proposing a girl, anyhow she will accept me. But when at the moment girl takes her own decision and rejects her, this hurts his ego, on which he just go and do such type of crime or taking any such type of attack. Because this is the happens because men were taught from the childhood that no one can reject you, no one can say no to you because you are a man, and woman has no right or no power to take her own decision. This time one more thing which I have to explain you, women, the fact of acid attack the girl is facing, there's maybe three consequences which I have taken in mind for this webinar. That is, there are three consequences which happens to you. First consequence happens when the physical consequence, when such acid attack takes place to a girl. Physical consequence is that her whole face or the part of her body where the attack has taken place totally get destroyed. Due to which the second consequence occurs, that is his psychological consequence. This psychological consequence occurs because of the social consequence. Because in our society, either the girl is living at a home or she is in employment. Most of the time we think that she should look very nice, her looks must be very nice. But when the attack takes place, it's suddenly the view of the society or anyone else suddenly changes for her. Like if she is working in a employment field, the employer just tries to dismiss him from the job, dismiss her from the job. Like, and if she is living in any house of rent, they tell him to leave the house because the most of the time even the families leave their girl child because they feel shy. They think that what the society will say. The main point now, except apart from this legal point in my short, because the most of the legal which I have prepared to explain you all this for a provisions and laws had already been explained. The main, not only it is a duty of our law, not only it is a duty of police administration, it is also a duty of our society. We ourselves only have to take stand for it. First of all, if we take the question ki acid laws were made for not selling the acid, then it is a whose duty? Government has made the laws for it, but now the duty comes on us to follow that. Like there are some acids which we use, not only they're not only pure acids, sometimes we use such acids either for the cleaning purposes and for other purposes. They are selling, and some changes should be taken for it. If we are thinking ki some shopkeepers who are taking such
Ma'am, unmute yourself. Yes.
Yeah, the main point is we the society, laws were made for us, laws were made for everyone, not only for the person who have to follow, that is either for police administration has to follow it. The main duty which we are speaking for it should be the way. You are getting my voice?
Yes, sir, ma'am. Yes, ma'am. It is quite audible.
Because there are some discussion for it. In my view, I'm also working for the District Legal Service Authority, and sometimes one question has been asked by Avijit sir, by one of our participants, for one-stop center. I have went to one-stop center because in District Legal Service Authority and also during our PIL, which I filed for the safety of the women and children. In one-stop center, the rehabilitation take place like they take the girls who are there, they just give them more education or whatever they feel they are interested, they give them the platform for it. In such way, they are providing them the rehabilitation. And the more
Okay, I think there is some technical glitch. So we can wait for another 10 seconds. Otherwise, we will invite another speaker. She's in waiting room. I'm adding. Hello, Ankita ma'am.
yeah, now it is unmute.
Yes.
Now, in some details, I'll talk about the three consequences which I said, because there is some more, I think some more network error is taking place. In the physical, there are three consequences which take place for the victim when she gets survived. Because the main question is if she is getting survived, whether she really survived. Because by the mental health, she is survived. But what about the other consequences which she has to face? First of all, the physical consequence she is faced due to the acid burn. That is we know very well the two-layer skin get fully damaged. That is, it also damages the fat and the muscle. Sometimes the heavy acid also damages dissolves the bones. If the surgeries take place, the surgeries are only to show the face. They can not be properly stored. Secondly, because of this, they get in psychological way mental trauma take place for them. Mental trauma like this, they themselves feels that we have got the disfigurement, now we don't look. Sometimes most of the cases, if we not support them or if not speak to them for the mental trauma. And the reason behind it is
Hmm?
So I think she
Yeah.
has, she's in the waiting room. Right?
She's in waiting room. I'm adding her.
I admit.
You're getting my voice. I'm sorry there's too much of disturbance.
No issue, ma'am.
Because I'm in here.
It's a technical glitch.
Now I'm talking
Nobody
now
has.
about the psychological consequence. Psychological effect can be more painful not only for the victim but also for the whole family. Victim lives with the material image that she has been disfigured and now she's an unacceptable part of the family or the society. She lives with the regret of being helplessness and unable to improve the situation which has been offered to him. Sometimes the mental conditions also develop inside them, that they are in depression, insomnia, or nightmares attacks. Sometimes she treated like an alien. The word alien, so-called, the more looking towards her physical condition. And the second consequence happens to them is their social and economic consequences. In social economic consequences, the victims of the acid attackers who are unmarried are unlikely to ever get married because the society is not in broad-minded enough and still to accept the permanent figure of women in their family. They were refused from their jobs. They do not have the personality. The employer is looking for their presence and might negatively affect the profit of their business. And what has been done in many positive steps has been taken now. But at the earlier stage, when there were no more laws and people were not aware about it, they simply rejected the victim. But now the like 2%, like this one Lakshmi Agrawal, the case of the victim, she has been married by a one that is local reporter who has taken a step to get married with him. And the most secondly.
Since we were facing these kind of issues from the last 2 years, so we have to bear with the technology. So wait for another 1 minute and then we'll start. She's in waiting room. I'm adding.
Yes, sorry. There are some reasons which I have noted. I think some error has been taken because of the loss of the electricity at my home. The Wi-Fi connection is getting too proper. That the one point I have said, when love turns into hatred. This is the main cause for the acid attack. This happens when the girl refuses the proposal. Secondly, the denial of sex. Thirdly, the ego. Now, in short, I'm summoning because so much of network error is taking as whatever the preparation I have been done is totally getting destroyed because of it. Something my this is that not only the laws, not only the provisions, and not only the regulations which has been made for us are enough to stop such attacks. We, being a society, being as a legal citizen, should also take some step forward for stopping such attacks. Any questions you can take because so many getting taken.
Yeah, ma'am, it was a wonderful session actually. So we do have two queries specifically from the role of District Legal Service Authority in this matter. So the first question is from Ujaswini Kohli, and she's asking, what is the role of District Legal Service Authority in case of these acid attacks, ma'am? Hello, Ankita, ma'am.
I'm not getting your voice also.
Okay. Am I audible, ma'am?
No, I can't hear you.
Okay.
You're getting my voice, but I'm not getting your voice.
Okay. Ma'am, I'm dropping the question in the chat box actually. The role of hello. Yes, ma'am. Am I audible to you? I think my voice is not clear to her. So moving ahead.
Sir,
Yes, ma'am.
she's not able to unmute, I understand. Please unmute her.
Okay, ma'am. Yes.
So there is connectivity issue.
Yes, there is a connectivity issue from her side. So hello, Ankita ma'am, am I audible to you?
Audible.
Yes. Okay. So I'm repeating my question now. Ojaswini was asking, what is the role of District Legal Service Authority in these acid attack cases?
There were steps were taken. I just tried to the scheme which has been mentioned by National Commission. I just tried to open how to share the screen.
Ma'am, you can share your screen. I have given you the right. I have made you the co-host.
Okay. You are seeing here. Are you getting it?
No, ma'am, not yet.
Yeah, just a minute. Just share. I'm prepared. Okay, I just said that schemes made by the DALSA.
Okay.
They are for some wealth award which has been provided to them. So they have started that for DALSA. If we have to take the award that is for the compensation which we have to take. In DALSA, there is one of a victim himself or either by the dependent or by the SHO. They should apply to the DALSA with their FIR immediately after registration with the State Legal Service Authority. Application for award of compensation which can be filed by victim along with copy of FIR or whatever the criminal complaints and medical reports were there. There are access of the mandatory reporting of FIR and where to file the application. The application for compensation which can be moved before the State Legal Service Authority or with concerned District Legal Service Authority. You are getting it?
Yes, ma'am. Yes, ma'am. Thank you so much, ma'am. So moving ahead with the program, I would like to introduce the last resource person. Last but not the least, he is Mr. Abhijit Kumar, a corporate executive with a career in the diverse roles spanning over 33 years. He is presently serving on the board of Bharat Connect Technologies and Subscription Limited. He has had a rich and huge experience of working in agro industries, infrastructure development, and in the corporate social impact initiative sector. He has been associated with the Acid Survivors and Women's Welfare Foundation, a leading non-profit organization from its inception in 2010. The foundation has been granted consultative status to the United Nations Economic and Social Council. The foundation extends assistance in the physical, psychological, and social rehabilitation of women victims of violence and those who are economically disadvantaged and to uphold their human rights and live a life of dignity and honor. The foundation has a pan-India presence with the chapters in Kolkata, Delhi, Mumbai, Meerut, Chennai, Patna, and Bhubaneswar. And we are very fortunate enough to have you with us, sir. Sir, over to you. I'm handing the session to you, sir.
Thank you, Professor Gupta. I would like to, as the onset, thank the Prestige Institute of Management and Research and the National Commission for Women for giving us the opportunity to, on behalf of our foundation, to present to you some of the findings that some of the studies that we've conducted and some of the findings where we've been facing challenges, and also to give you some possible suggestions and take your guidance on how we could take this forward. May I request Professor Gupta to kindly allow me to share?
Yes, sir. You can share your screen, sir. I have given you the right.
Okay. Okay. But that is taking time because each region getting cases and having data translated and compiled is taking time. The connection for the study for Eastern India is complete. So I'd like to just present to you some of our findings. Okay, of course, as you are all aware that acid crime, there's a difference between the throwing of acid and other forms of violence, in the sense that the intention of the perpetrator in acid crime is not to kill the victim, but it is in most cases to disfigure, maim, and torture the victim so that they are repentant for a very long time. It is different from other forms in this sense. Now, in terms of India's position, see, acid violence is a worldwide phenomenon. It is happening in a number of countries around the world. You'd be surprised that, of course, as of this is between the last 5 years, between 2016 and 2020, India has the ignominy of being the country which is most affected by acid violence. But it may be a surprise to some of our younger viewers, maybe our students, that the second country in concern is the United Kingdom. The United Kingdom had the ignominy of having the highest incidence of acid violence. In fact, even today, per capita, it has the highest incidence of acid violence. In 2007, the acid violence in the UK exceeded us by almost twofold. Ours was 252, there was 400 and something. Then, of course, there's the South Asian countries, that is Pakistan, Bangladesh, Nepal, and then the West is also coming under this to a very small extent. But I will come back to UK later in the under the challenges, and to saying in the last 3 years they've done a very commendable role in controlling acid violence. In terms of all India stats, you'll find that acid violence, of course, in the last 1 year has declined. That's primarily, well, if I might say, thanks to COVID. But otherwise, you'd see that there was a slight rise in 2019 compared to 2018. It has been declining, and 2020 there has been a decline. You see, right from 252 to 186 in 2020. Now, in terms of the regions that are most affected, you would find that the eastern region is most affected. 37% of the attacks in the country happen in the eastern region, 35% in northern region, 15% in southern region, and your side, that is Western India, has the least amount of acid violence at 13%. In terms of the states of India, which is most affected by acid violence, you'd find West Bengal, followed by Uttar Pradesh, have the lion's share. That is, West Bengal has about 300 attacks, Uttar Pradesh about 250. And then you have the rest of the 8 states, which is around 50 attacks per year. Madhya Pradesh is 8th on the list in terms of acid violence, but this is the scenario. Out of the total 1,235 victims of acid attack between 2016 and 2020, this has been mainly triggered by West Bengal and Uttar Pradesh. This is the all India position in terms of states of how each region has been facing this malady. Now, in terms of the victims, you would find that the distribution, you find most acid attacks have taken place in rural India. This was surprising for us. We thought that this is an urban phenomenon, but we found that 60% of the attacks are in rural areas, followed by 24% in suburban and 16% in urban areas. We thought that the trend would be otherwise. But this also involves migrant workers who come in from outside the city limits to work in the city and go back. Of course, time of attacks, most of them have taken place during the day. Those have taken place at night have been far, far more serious in terms of the gravity of the situation. 64% of the attackers have taken place around the residence of the victim. Now, although there can be no reason to justify acid violence, our study shows that 36% of acid violence is an account of rejection of marriage, love, and sex proposals. 13% is an account of marital discord, 5% family disputes, 1% and professional jealousy. Dowry accounts for 5%. Land disputes is a major issue and is growing, is at 11%. In terms of the victims of acid violence, we find that most of the victims are in the age, that is for girls, are in the age group of 11 to 30 years. And for men, it is 20 to 40 years. 65% of the victims are women and girls. 35% are men and boys. In terms of qualification, 46% of the victims are non-matriculates. Socioeconomic status, this is where I would like to highlight this maybe slightly, is you'd be surprised that most of the victims, namely 47%, are students. And when it comes to rehabilitation, I'll come back to this point on the challenges of getting this. That means almost half the cases of acid violence involves students and the challenge of getting them back to school or back to college. Okay, 81% of the victims are from middle and weaker socioeconomic class. This is another area where we are finding that increasingly over the last 4 years, we are seeing more and more people from the affluent classes being affected by acid violence. This is a concern. This is in terms of the perpetrators of acid violence, the people who are carrying out the acid violence. We find that the vast majority, 52% of the attackers, are in the age group of 21 to 30 years. 87% of them are males, 13% are females. in terms of the chemicals used, the type of acid used, most commonly hydrochloric acid is used. It's muriatic acid. It's, of course, as one of my previous speakers he had mentioned, that unfortunately this muriatic acid is freely available in the market. Only thing is that the name has been changed. They are no more labeling the bottle as acid. They've renamed it as washroom cleaner or special cleaner, and this is available in the market. So I would of course take your suggestions on how this bypassing of this provision can be corrected. So you find even it's even available in the malls. It's the same acid produced by the same person. It's only labeled differently. The next acid that is used, of course, is sulfuric acid. This is available in terms of battery acids. Of course, people work on making it more concentrated. Nitric acid causes the most amount of harm. Unfortunately, we see the least amount of cases with this form of with the use of this type of acid. In rural India, carbolic acid is most commonly used for attacks. Now, this is again readily available. It is used by a snake as a snake repellent in the countryside, and where people use that for attack. Now, the impact that acid violence is having, I mean, I'm sure you've gone through this, so I would not repeat in terms of the physical impact and psychological impact on the health of the victim, and of course, socioeconomic impact that this has. I'll straight away come on to the challenges that we've been facing as a result of this on 4 verticals, namely the medical challenges, the investigative challenges, the judicial challenges, and the rehabilitative challenges. Coming to the medical challenges, we find that I'll read some of the data from that we've got. In terms of medical treatment, we find that immediately after an attack, getting medical treatment is the easy part. That is the time all hospitals across the board, whether they are private or government, readily admit a victim. Getting support for helping the victims immediately after an attack is very easy. I mean, everyone wants to come forward to help. So the initial treatment is provided or is made available to victims across the board. The challenge starts at the next stage, and that is subsequent treatment becomes very difficult. The reasons for that is primarily, you see, because the treatment is expensive. I mean, if I just run through a little table, on an average, this is for Eastern India, but I mean, I suppose it will be more or less the same across the board. On an average, a victim goes through 11 times gets hospitalized 11 times, undergoes an average of 9 surgeries. Maximum has been 27, minimum has been 1. Stay in the hospital on an average is between 231 days in the course of course, in the course of 9 surgeries. Total expense average is 6,21,000. So this is expensive. I mean, what the challenge that we have is to have a comprehensive treatment plan. What we would really suggest here is if the victims can be placed in front of a medical board where you have specialists from different fields, namely plastic surgery, ophthalmology, ENT, orthopedics, psychiatrists across the board, and they assess the victim and draw out a comprehensive treatment plan. The treatment plan could be in stages. Stage 1, these are the procedures. Stage 2, these are the procedures. Stage 3, these are the procedures. if this is done for all victims, and if this is monitored by a certain agency at the district level, then whenever victims, see what happens here is that for subsequent treatment at government hospitals, it becomes difficult because government hospitals have a limited number of beds in the burn ward. And priority is given to new patients. Somebody who's coming in with a fresh burn would be given the bed on priority. Subsequent treatment is not on priority. So dates for subsequent treatments are only given on the basis of availability. Now here, private hospitals play a major role in the sense that they organize medical camps or surgical camps. That is where we send victims from all over. Say we had a recent medical camp by Max Hospital in Delhi. So we sent victims from all over the country to Delhi for treatment. Now, unless this comprehensive treatment plan is drawn up, treatment is done on a piecemeal basis. I mean, assessment is done and treatment is given. If it is on a comprehensive plan, then it makes it easier for the NGO to prioritize treatment for the victims, A, and 2, it makes it easier for us to get donations from crowdfunding. Then we know that the next procedure is going to cost so much, and so we are able to plan that in advance. So if the comprehensive plan is not there, I mean, we, as of today, don't know the next victim, how many more surgeries are required. Is it required on priority? Because everyone wants their surgeries to be done. But we cannot prioritize them, nor can we draw up a financing plan for them. So this is one of the challenges on the medical side. The other thing is, of course, the need for skin donations. So see, the need for skin donations is skin donations are very urgently required. Unfortunately, it's not readily available. Although skin is donated from cadavers, from dead bodies, but there is not enough awareness, A, and 2 is there is even the skin banks that we have in the country are literally running empty, except for one skin bank that we know of in Bombay. The others are very short of skin that way. So this is something which needs to be promoted in a big way, as artificial skin is very expensive. Okay. There is also a proposal for, if it is possible, I mean, to get tax exemptions for corporates. I mean, if corporate organization is giving treatment for money for medical treatment from their CSR funds, is it possible to get 100% tax exemption? This is something I'd like to take your suggestions on this. Importance of giving wide publicity to first aid. I'll come to that. But before that, there's another thing that I'd like to mention is that medical insurance does not cover subsequent treatment for acid violence. It covers the initial attack because that is taken as an emergency condition. The insurance companies pay for that. Subsequent treatment, it is considered cosmetic. So this is where, of course, where we have a constraint in the sense that, yes, some of it is cosmetic, true. More of it is functional, because what happens after each surgery is there certain contractures that form. Those need to be released. So our priority is to really give relief to the victim in terms of functionality. It is, we'd rather say that the victim needs to move their neck or be able to move their neck more than, look better. So this is the medical insurance side is another thing which we would need help on how we can get around that. The one about the first aid, this is mainly for our students who are watching this program. I'd like to show you a slide. This is mainly for the students. I mean, if you look at the pictures of the victims on the left and the picture of the victims on the right, the victim on top suffered 4% burns. That means 4% of her face was burned, surface area of her face was burned. She did not flush the face with water. She simply wiped the acid off with cloth. She required 2 surgeries, 15 medical procedures, hospitalization for 30 days. And as you can see her picture on the right, the top right, you notice that there are still permanent scars on her face. Now, if you look at the picture, the bottom left, this girl suffered 2% burns, and she poured copious amounts of water. For at least, she kept pouring water continuously for 2 hours. Notice that she required no surgery. Hospitalization was 6 days, and if you can see, yes, there are scars, but it's not very visible. So the importance of pouring water for first aid, if you see anybody, hear anybody, see somebody who needs help, this is what we can do as an immediate consequence. I mean, of course, we always suggest that prevention is better than cure. We would definitely advocate prevention. So we do a lot of these awareness campaigns. We make people aware of this form of violence so that they can take, and in that awareness programs, we have made models of immediate precautions that need to be taken, of how to prevent this thing, of red flags, warning signs, and mitigative measures. But despite taking all preventive measures, should someone be unfortunate to come under this form of violence, this is the first aid measure that one would require to undertake. Okay, now coming into this is the medical challenge. Now coming to the investigative challenge. Now, I must apologize at the onset. The figures may not be very pleasing, but the purpose of this exercise is to present you with facts, irrespective of whether we like it or not, and take your suggestions. I mean, we need, I would like to be very clear on this. We need your help. We need your help. We need your guidance. We need your suggestions. We can present you with the facts that we are facing on the ground. And we would need your help to guide us on overcoming the challenges. In terms of the investigative treatment, the investigative challenges, I will present again the figures relating to Eastern India, because that is where we've completed our study. This is in the last 5 years. Out of the 80 FIRs, 80 FIRs that were filed in the last 5 years, 12 cases, that is 15%, is still pending. Now, if we take the time frame for this, there are 2 cases that are pending for 2 years. Is there a way that we can expedite this? Of the 80 FIRs lodged, 20 cases, that is 25% of the FIRs, resulted in final reports which are not in favor of the victim. The case was closed. The complaint that was put on the FIR could not be substantiated at the investigative stage. Now, I will come to this portion of, it was of course very correctly mentioned by Sir previously, that of the challenges of defective FIRs. And as Mr. Gandhi very correctly pointed out, that I'll just run through the process a little bit on the challenges, and it in some ways maybe a slight repetition. Immediately following an attack, see, most of the attacks are on the face. The victim is not in a position to speak. As you saw, 37% cases are relating to rejection. So there is some lovey-dovey angle to that. The victim is in a dilemma. If the parents are not aware, do we tell them the truth or do we not tell them the truth? In most cases, at this stage, in most cases, I'm sorry, they do not come out with the truth. They are scared to tell their parents the truth. The truth comes out. The truth comes out, but that is unfortunately after about 10 days. I'll come to that. Initially, after the attack, the victims are bandaged and not in a position to speak. The victim is taken to the hospital. The hospital says it's a medical legal case. We're required to file an FIR. The parent parties, that is the guardians and others who brought the victim, generally go to the police station. Most of them have not seen the incident taking place. They've heard the things from a third party. They file an FIR on hearsay, what they have heard and said. In most cases, it is a generalized kind of a thing. It's a very vague, very open, very generalized kind of a complaint. They are simply complying with the provisions required by the hospital. They're not thinking about about anything else at that stage. It is only after, and in some cases, I'm sorry, in some cases, it is the parents or the guardian of the victim who are responsible for suppression of facts. Some of them that we know, they say that, okay, we have this, if this gets publicity, we have more children at home. It will be difficult getting them married. Some say, okay, if the public get to know about this affair and thing, it'd be difficult to get this girl married at a later stage. So they tend to intentionally sometimes suppress facts. So this results at the onset with a defective FIR. Again at a later stage, what happens is in about 10 days time, when the skin on the face starts dying, the skin initially blackens, depending on the type of acid, of course the coloration is different, but within about 10 days the skin on the face dies and the dead skin is required to be removed. It's excised. So once the skin is peeled away, that is the time when the victim sees the reaction on other people's faces and realizes for the first time that I will never be the same again. That is the time two things happen. One is depression sets in, and two is a revulsion and anger comes in. That how dare he has done this to me. When that anger and revulsion comes in, then the truth comes out. That is the time when they don't care who knows. I mean, irrespective of whether my parents know or not, this is the truth. This is what happened. This is what this person did. So that time the truth comes out. And the investigating officer at that point of time takes down the details from the victim. That is, normally after 10 days, the victim is in a position to speak. So it takes down the victims and it comes in as a subsidiary FIR is filed. Unfortunately, this is when this comes into the court, that is the time the defense literally rips into the prosecution, citing that this is an afterthought. The initial FIR did not mention any victims' names. The subsequent FIR, they have tried to frame this person who is innocent as an afterthought, included his name. And it's very difficult unless one has strong evidence to back the case at that time to get it to stand. I mean, I will come back to that at the time of judicial challenges, but this is one of the challenges here. Okay, so what I would like to reiterate here is that out of the total number of cases, out of 48 cases, 60% of complaints resulted in submission of charge sheet. That means 40% of the FIRs were lost out at the investigative stage. See, out of 20 FIRs that were lodged, as an example, it is only 60%, that is 12, that have made it to the court. So there is the need to see how this figure can be increased. Of course, A is necessary to counsel the victim and the family so that they come out with the truth, because unless the investigating officer is told the truth, it's very difficult for him to investigate. And of course, there are pressures on the victim, or pressures on the witnesses, compound matters further. if I just run through the list of the shortcomings in the investigative stage, it is A1, inadequacies in the FIR. Sometimes the investigation is flawed. Here, of course, we have little suggestion. I don't know if it is at all possible, but if investigations can be done by a specialized set of officers, because you see, normally there is law enforcement and investigation. So if and of course, the department does have a lot of constraints in terms of number of available officers, and the pressures, work pressures are increasing on them tremendously. But if the investigation can be done by a specialized department in the police force, then maybe this could this figure could be improved. There is this lack of identification of perpetrators is a major issue. Of course, there are lack of witnesses who are willing to testify and undergo the prolonged ordeal that it entails, coming to court repetitively and things. And of course, this the conversion of figures from FIRs to final charge sheet is what is really the challenge that we face, the major challenge that we face in this. I will come to the next head, that is the challenges at the judicial stage. Again, here I must apologize at the onset that the figures we present may not be very pleasing. As I said, a total of 48 charge sheets were lodged in the last 5 years in our case for this region. Out of the 48 charge sheets that were lodged in the court, 40%, that is 19 cases, are still under trial. I'll come back to the delay and the number of cases and how many cases are pending. I'll come back to that. Out of 27 cases, 16 cases, that is 59%, resulted in acquittals of the accused. And in only 27 cases out of 41% resulted in conviction. That means from the total number of cases that were filed in the court, 41% have resulted in convictions in our case here. So if we take it in terms of total number of FIRs filed to convictions obtained in the court, it comes to an abysmal 26%. I'm mentioning about FIRs filed in the police station to favorable judgments got in the court. Convictions that we got in the court is from our region standing at 26%. So this low conviction rate has created a perception that acid violence is a low risk crime. In terms of delay in judgments, I'll give you that case which I was mentioning. Cases that are pending for less than 1 year are 11%. Cases that are pending between above 1 year and less than 5 years, 63%. Cases that are pending for more than 5 years, 26%. Is there something that we can do about this? We, of course, always pray about fast tracking of the cases, but we are informed that there is shortage of infrastructure. Is there something that can be done? Of course, you'll appreciate that cases that are going on beyond 5 years, it is difficult for us to sustain the enthusiasm of the victim. It is difficult for us to keep holding on to the witnesses together for this prolonged period of time. Regulating the sale of acid. I was very encouraged with Sir when mentioned that the police department in Madhya Pradesh is looking into the enforcement of this there. I'm very encouraged, sir. I wish this was being done for other regions also. The truth for regulating sale of acid in other regions is that there is no agency who is taking the onus of doing that. In our case, the ball is passed between the police department and the inspectors of the drug and poison department. There was a food and drug department in the corporation. It gets pushed between them on who is going to be enforcing this. And as a result of this, there is no enforcement, I'm sorry, in our region in terms of this. In terms of compensation of victims, this is one area where commendable work has been done. Victims across the board who have their papers in order are getting processed for compensation. Unfortunately, here the rate of compensation varies from state to state. There are certain states which are paying 3 lakhs to certain states which are paying up to 20 lakhs. Now, is there a way in which uniformity can be enforced? Is there a way in which there can be a table saying that so much disability, person has lost both eyes, one eye, that this is the rate of compensation? Can there be some kind of a tabular form where this is done on a uniform scale, so that there is no disparity between state to state on this count? Okay, here it would not be out of place to mention Bangladesh. The reason I'd like to do this is when our foundation, the Active Survivors and Women's Welfare Foundation, started work in 2010, we had a lot to take from our counterparts, the Active Survivors Foundation, Bangladesh. They had started work 10 years before us. So we had a lot of their success stories and a lot of their cut and dried program which had been successful. So we could emulate from them in a lot of ways. Now, in the last 10 years, between 2002 and now, acid violence in Bangladesh has reduced by 70%, 70%. What is it special that Bangladesh has done that we could possibly do? In 2002, Bangladesh passed 2 acts. One was the Acid Control Act 2002, and one was the Prevention of Acid. I'm sorry, I'll get you the name. Basically, they passed 2 acts in 2002. In that act, what they did was, I'm not quoting legal language, as a layman, in layman's language terms, one of the provisions in the act said that if a person throws acid and is caught and convicted by a court of law, the person is liable to hang. Now, it would not be out of place that not one person has been hung in Bangladesh in the last 10 years. But this provision has worked like magic in terms of creating awareness. When our counterparts in Bangladesh have gone around schools and colleges, they've simply said, you throw acid, you get caught and convicted, you're going to be hanging. And this has given the perception that this is too high risk a crime. It's not worth throwing acid, getting caught and getting hung. So this has been a major, major, major deterrent. The other thing, of course, in the provision was very fixed timelines for investigation, very fixed timelines for hearings in court, very strict timelines for this. And they have, maybe this is again for our students who are watching this program, those of you studying law, if you're interested and you'd like to take up a study on comparative legislation to see what are the provisions in Bangladesh and Pakistan and Afghanistan. In UK, in the last 3 years, they've done commendable work. Their prosecution and conviction rates, as I was saying, ours, which from the stage of filing of the charge sheet in the court to getting a conviction is 46%, right? In the case of UK, it is at 97%. Now, if you study their provisions, maybe there could be something, or maybe suggestions could be drawn up in our context. Some of course, the provisions would require translation, but if you're interested, that is maybe something that could be done on this. In the rehabilitative aspect, our challenge has been, as I was mentioning earlier, 47% of the victims are students. And it is really difficult to get a student, convince them to come back to school or college. They feel that it requires a lot of counseling, a lot of psychological intervention to bring them back. And in this, you'll be happy to know that we've been able to make a headway. We've been very encouraged. We've been very encouraged in this. We did send some of our students to a college in Chennai, Satyabama University, and there it is not only the students and the faculty who took them in with open arms, very commendable on their part. But we were most encouraged that it was the people who are outside, the common people, the auto drivers, the bus drivers, the shopkeepers outside, who again accepted them the way they were. That has been very, very, very encouraging for us. And I think that as an example will open the floodgates for other places, for other students to come out and resume their studies. Of course, this thing is on in terms of housewives, getting them back on through skill development. In terms of the rehabilitative aspect is the major aspect that the foundation works on. We've been getting them trained, getting them into jobs, and getting them to restart their lives again. Here we would like to mention another area, and that is, of course, I'll just take you a little bit through the work that the foundation has been doing. We started in 2010 under the chairmanship of Dr. H.P. Bhadoriya. It's a non-profit organization, and we have linkages with Survivors Trust London, which is parent body. Of course, this is we are starting our chapters in other places. This is the chapter in Chennai. We're starting that. Then this is some of the self-help victims we have rehabilitated. This is rehabilitation skill development work in progress. Awareness programs, schools and colleges. Surgery camps that are done. Awareness for police officers, sensitizing them. We brought out something called a trauma-informed care kit. That is for all persons who are involved in working with acid survivors on how to deal with them, how to be sensitive towards them. So there is a kit, a book, which we've also brought out for sensitizing them. There's other programs like we've had something called where artists have donated their paintings for support of victims. Proposed way forward, there was mention of one-stop crisis center. I think ma'am clarified on that. Yes, I seconded completely on this. I think it is absolutely essential. This one-stop crisis centers are a real boon. See, because there's another challenge that we have in terms of this is the coordination. I mean, you see, there is no the focus of all the service providers, right from doctors to the investigative officers to judicial officers, is the same: to give relief to the victims and to punish the perpetrator. But in this, what happens is it is like a football team, unfortunately, playing a disjointed match. The focus is the same. The goal is to win. Unfortunately, see, the end, the scoring is done by the prosecutor in the court. So the inputs have to come to him. It is sometimes there is the need for backward integration. The one-stop crisis center has everybody under the same roof. So it's possible to backward integrate. I mean, it is the public prosecutor who could speak to the investigating officer and say, your reports must cover points A, B, C, D, E. And similarly, the investigating officer could speak to the medical officer and say, your medical report should cover, these are the points. So these are the loopholes that need to be covered in your report. If there is this integration or communication or teamwork between this, I'm sure we can improve on our conviction numbers. Okay, there is of course on the legislative recommendation, there is the need to criminalize unlicensed sale of acid. If somebody is selling acid in Nandvi, is it possible to criminalize them and punish them? Legislation that provide for legal, medical, and other types of rehabilitative services for victims. At the moment, it is done by the NGOs. Can there be some provision which mandates this? Is there, as I was mentioning, is there a way that we, is there a way through legal provisions that we can mandate that investigations be completed within a certain time, or cases heard in a court within a certain time frame? Is there something that can be done on this? In conclusion, of course, as you're aware, this is the worst form of, is one of the worst forms of violence. And unfortunately, not a week goes by without some report of some violence somewhere coming up regularly. As Swami Vivekananda said, the best thermometer to measure the progress of its nation is the treatment that it gives to its women. I sincerely hope that this is not lost in the populace of India. I mean, on this score, I'd like to mention two small points for the future. I mean, in terms of long-term solutions. We feel that this form of violence has got two roots. One is the need for gender sensitivity from young age. If children from a small age, as toddlers, if they are taught to respect gender-wise, they are taught to respect each other as equals, the importance of this. See, at a village level, or what we have frequently have here, is we find that the male child is given more prominence, is given more benefits. It may be the mother and the daughter eat last, get the smaller piece of fish, whereas the son is given the bigger piece of fish. I'm just giving you an example. I mean, there is pampering on this score. When it comes to the city, as it's fairly common today, to see that if two siblings, a boy and a girl, get the opportunity to study overseas, generally parents today will prefer sending their son overseas. They will say, daughter, keep her with us, unless she gets bad influence. I mean, this favoritism is still being practiced, but this is a message for you youngsters. If you are able to enforce in your younger siblings, and later on when you have your families, if you're able to enforce gender neutrality in children from young age. The other important thing which I would like to stress is, again, focusing on youngsters in the crowd, is the importance of saying no, N-O, no. In today's time and age, we have most parents who are working, both father and mother working. They kind of feel guilty that they are neglecting the child or not giving enough time or not being so-called quote unquote a good parent. So there is the tendency to appease children, give them whatever they want. They demand something, you give it to them immediately. There is the importance of saying no. And there is the importance of the child accepting no as an answer. See, when children are appeased for or given whatever they want to, later on in life, if somebody says no to them, that no is taken as an insult. They're not able to accept no as an answer. When there is a lovey-dovey affair, it is only fair that somebody can say no, it is their choice, right? But if they get no as an answer, then they feel they are insulted. They feel that they have been wronged. They feel that how dare can somebody say no? They're not able to accept no as an answer. So it is important to inculcate this habit of saying no, and for the child accepting no as an answer from childhood. if these two things of being gender sensitive, sensitivity also comes from an example. If a child sees a father hitting the mother, then slowly, the child may think that this is accepted form of behavior. So it is important to be a good example to our children. So if there is respect that we show one another, and if this gender respect is inculcated from childhood, and children are taught to say or accept no with humility, then I feel in the long term, there could be more hope for getting over this quickly. At this, I would like to once again take the opportunity to express my sincere gratitude to Professor Akash Gupta and his team at the Prestige Institute of Management and Research, Gwalior, the National Commission for Women, for giving us the opportunity to participate in this wonderful webinar. And I also like to thank all our co-hosts who have given their valuable inputs. I've taken a lot of your notes, sir, ma'am, and we will try on developing on those further. I'd like to take this opportunity to say thank you to you all. Thank you, sir.
Thank you so much, sir. It was a very informative session from your side. It was truly based on the facts and the figures. So you just explained each and everything in a very systematic manner, as well as the facts which you were relying upon. I'm inviting the associate professor. I'm inviting head of the department, Dr. Prabal Pratap Singh, to propose a formal vote of thanks. Over to you, sir, Prabal sir.
Thank you, Akash sir. Am I audible?
Yes, sir, you are audible.
Okay. A very good afternoon, all respected dignitaries, faculty colleagues, staff members, participant and volunteering student. I feel honored and privileged to get an opportunity to propose a vote of thanks on webinar of Defense the Acid Attack Resilience Against Violence, sponsored by National Commission for Women, NCV, New Delhi at Prestige Institute of Management and Research, Gwalior. I, on behalf of Prestige Institute of Management and Research, Gwalior, respected Director Sir Dr. Nishant Joshi, Deputy Director Dr. Tarika Singh, Deputy Director Dr. Namita Nathani, entire faculty colleagues of the Institute and volunteering student, and my behalf convey deep regards, heartily thanks to resource person of the webinar, Mr. Ravi Bhadoriya, ISCSP, Maharajpura Circle, Dr. Vikas Gandhi, Associate Professor, Gujarat National Law University, Mr. F.A. Shah, Advocate, Honorable High Court, Madhya Pradesh, Ms. Ankita Mathur, Mediator, District Legal Authority, Honorable High Court, Mr. Abhijit Kumar, Assistant Director, Asst Survivors and Women Welfare Foundation, for sharing their vision with us of developing legal practices to match the best in the world. I express my sincere gratefulness to Dr. Nishant Joshi, Director, Prestige Institute of Management and Research, Gwalior, for his continuous guidance, support, and motivation. I also express my sincere gratefulness to Dr. Tarika Singh, Deputy Director, and Dr. Namita Nathani, Deputy Director, Prestige Institute of Management and Research, Gwalior, for her continuous guidance, support, and motivation. I would also thank respected faculty colleagues, PIMR Gwalior, for their relentless and continuous support. I also thanks PIMR Gwalior's student volunteers for their support and relentless hard work. Alone we can do so little, together we can do so much. I finally convey thanks to the whole team of Prestige Institute of Management and Research, Gwalior, for making this webinar successful. I convey thanks to the IT department of the providing constant support. We assure to continue to work in the direction of the creating knowledge in the field of legal education, and research. Through this platform, I want to call upon all such scholars of law that if they want to hand over the best knowledge to the new generation regarding their method, for this, the doors of the Law Department PIMR Gwalior are open for you all. Thank you and have great day ahead. Over to Akash.
Thank you so much, sir. Moving ahead, there is another slide. Actually, I am a very passionate writer, so I have written something on this topic. Although it's a very cruel thing to see all these cases in the society. Like we are living in the developing society, we are not living in the primitive society. So I have written something on this particular topic. I hope you will like it. So the next slide would be related to my creation, which I have written on this particular topic, and I'm going to read it too. So आत्मा जब मेरी मारना चाही थी, दरिंदों ने तेजाब फेंक कर, वहशियत भरे मंसूबों को पूरा करना चाहा, घाव गहरा देकर। बूंदे कहाँ तेजाब की सिर्फ जिस्म के हिस्सों को जलाती हैं, असहनीय दर्द शरीर के साथ मन को जैसे दे जाती है। हौसला मेरा डिगा ना सकेंगे, ना भटका सकेंगे मुझे रोक कर, चलते ही जाना है मुझे, आए भले कितने ही कठिन डगर। तुम्हारी ये हरकत एक निकृष्ट सोच ही हमेशा दर्शाती है, बात न मानने की क्या ये सजा बहन बेटियों को दी जाती है। मुझे झुका ना सकोगे, ना ही मेरे ख्वाबों के बीच आ सकोगे, घर जो ठान लिया मैंने उठने का, तो मुझे गिरा ना सकोगे। जरूरी तो नहीं सब तुम्हारी तरह मानवता भूल जाएंगे, हाथ थामने मेरा इस भीड़ में एक नहीं कई हाथ आएंगे। कानून है, नियम है और मेरे राष्ट्र का सर्वोत्तम संविधान है। शिक्षक हैं जिनके हाथों में समाज को सिखाने की कमान है। मेरा संघर्ष ही तुम्हारे इस कुकृत्य का मुंह तोड़ जवाब होगा। दुर्गा स्वरूपा शक्ति से अब तुम्हारा ये चेहरा बेनकाब होगा, अब तुम्हारा ये चेहरा बेनकाब होगा। Thank you so much.
Wonderful, sir. Wonderful.
Thank you so much, ma'am. So thank you so much to every single resource person, respected Vikas sir, respected Avijit sir, Ankita ma'am, CSP Ravi Bhadoriya sir, and Shah sir, for sparing valuable time with us. Thank you so much, and each and every single participant, registered participant, will get the e-certificate within 3 days. Thank you so much, ma'am. With your kind permission, may I end the session?
Sure, sir. We do not have any feedback link, or it will be emailed.
It will be emailed to the participant.
Right. All right.
Thank you so much, ma'am.